The simplest thing we talk about in the next 20 minutes, so I thought I'd get it out of the way right now. So do this at the end of the session. My name is Jonathan Zook, and I'm with an organization called the Association for Competitive Technology, which is an IT industry trade association in Washington, D.C. So we actually spend most of our time talking about public policy, talking about the rights such as intellectual property, et cetera, how those things are used and abused, what sort of enforcement should be in place for those things. And we talk about it not only in Washington, but around the world. So as a former software developer who used to speak on technical topics, it's a great pleasure to be here talking to you all in a semi-technical manner. But I'm going to try to talk about this from a practical perspective. And if any of you want to engage on some of the philosophical debates about copyright and IP and some of where that's going, Creative Commons, et cetera, I'm happy to talk about it in the hall after we've been ousted from the room. All right? So the first question is, what is copyright? And it seems like a silly question to try and answer, except that I feel like we're in the middle of a generation of people that have very little understanding of copyright. And particularly on the web, particularly in a sort of post-Napster world, people have made their own assumptions about what is legitimate and illegitimate use of copyrighted material. And so sort of to stay out of the way of cease and desist letters and angry rights holders, I thought we'd try to talk a little bit about what copyright was and how to make use of it, how to sidestep it, et cetera. So it is, in fact, a right granted by the Constitution, right? The Constitution specifies the ability of Congress to create a copyright for purposes of creating an incentive for creators in the arts and sciences, right? So this is something that dates quite a ways back. And it's a right surrounding a work. In other words, something that you create, whether it's something that you write, music that you record, et cetera, your actual work. So it's different than a patent, which has more to do with a method or an idea, et cetera. This is the work itself. So most of the software you create is covered under copyright. A trademark has more to do with your brand, right? Your name is your trademark, your idea is your patent, and your work is your copyright. So there's a lot of myths about copyright, and I get into these endless conversations with all of my neighbors and friends about what's okay and not okay. And all of you are in a position of designing websites, engaging on social networking sites like Facebook and MySpace, doing blogging, et cetera. And so these all become open questions in terms of art that you reuse, photos, videos, music, et cetera, that you make use of in the context of these different venues, right? And so there's a lot of myths about it, right? I mean, as long as I found it on Flickr, I can use it, right? Well, no, actually. That's not true. And so it becomes important to have a little more nuance in your understanding of how these rights are maintained and what kind of rights are granted to you on each of these sites. In almost every instance, a site like Flickr or PhotoBucket or SmugMug or Facebook or many others actually have a type of user agreement that does specify the rights that the copyright holder is giving up by posting material there in the first place. More often than not, the rights that they're giving up are to that company, not to other users, though. So it's important, if you really want to make use of a copyrighted work somehow in your own website, your own blog, that you familiarize yourself with the specific license that exists for that particular site. Your best case is that you should definitely cite the person whose work it is, not just that it's from Flickr, but that it's from the individual that took the picture on Flickr, for example. Another one of the myths that we hear all the time is, well, as long as I'm not making money. If it's a non-commercial thing, isn't it okay? And I hear that all the time, including copying each other's CDs and DVDs all the way to the use of content on the web. And the truth of the matter is, that is a consideration, but what ends up being a more important consideration has to do with the effect that your use has on the marketplace. So in other words, if you're preventing somehow a sale of that copyrighted work that might otherwise send proceeds to the copyright holder, it's an infringement. Whether you made money from it or not, it's less important, although still important, is less important than whether you prevented money from being made by the copyright holder themselves. As long as I'm only referencing the work that someone else infringed upon. So in other words, if I'm browsing on YouTube and I come across a clip from the Colbert Report on YouTube, can I just link to that YouTube clip from within my blog? And the answer is no. That's called contributory infringement. So the fact that someone else did the first infringing doesn't mean that linking to it then in your own site and promoting that infringement is somehow okay. That becomes a contribution to that infringement, and you need to be equally careful about that. And even the things that are user-created content on YouTube, again, go back to the agreements within the YouTube site to make sure that you have permission to repost those things. In most instances, there is some mechanism for doing that, and the site's architected around you doing that, but you need to be really careful about what rights the copyright holder have given up. Another one that is frequently talked about is parody. And we're going to talk a little bit about fair use, and that's the term that generates the exceptions, if you will, to these copyrights. And one of those things is about parody, that as long as I'm making fun of something, then I can make use of this copyrighted content. And that's a tricky issue as well, because it actually needs to be parody and criticism, not just parody. So, for example, Weird Al Yankovic's Eat It song is something that required permission from Michael Jackson for him to do. It wasn't something that he could do absent that permission, despite the fact that it was a parody, because it didn't contain criticism. So it's something you can't make an automatic assumption about. And even then, if you are trying to parody something, you're only supposed to take enough of it to be evocative of the work and not duplicative of it. And that leads me into the last one, which is I'm free to sample it, right, to talk about it, to analyze it, et cetera. And this is a very serious topic of discussion. But again, the same thing applies. You are free for research purposes, teaching purposes, analysis, news, et cetera, and commentary to take a sample of the work. But that sample should be the minimum size possible to be evocative of the work and to allow you to do that criticism. It shouldn't be the entire work so that you can then write a paragraph about it. So again, there's a lot of myths and a lot of assumptions that people make about copyright. So what is fair use? There's a lot of discussion about fair use and what that means. And what it is basically is the use of a copyrighted work for criticism, comment, news reporting, teaching, scholarship, and research. And it was built into the Copyright Act. So when Congress sort of came up with the copyright, they came up with these four purposes for which you could be affirmative defenses, which I'll talk about it a little bit. Though I'm not a lawyer, I'm a former programmer. I'll have to keep reminding you of that, even if I start to sound like a lawyer. The fair use is determined on a case-by-case basis. It's not well-defined, and that's sort of by intention. But basically, it's the purpose and character of the use. In other words, how are you using it? Is it for commercial purposes? Are you profiting from its use? And that's important. The nature of the work. In other words, was the work designed to be licensed and to be reused? The amount and substantiality, I must have made that word up for the purposes of the legislation, of the portion used. In other words, how big of a piece of the work are you using? How much of it did you really need to use to get your point across, to do your commentary, et cetera? And then finally, the effect of the use on that potential market. So in other words, if by making a copy of the CD for your friend, you're preventing your friend from buying a CD, right, then that's definitely an infringement, even if you didn't make any money associated with it. And it's another subtle point, but it's also not a right. Fair use isn't a right. The way that copyright is, it's an affirmative defense. And what that means is that you're ceding that you've made an infringement, but you believe that you made a fair use of that copyrighted material. So it's really something that comes up in the context of an infringement, of a lawsuit, et cetera. And so you need to be very careful in terms of how you go about planning for the use of copyrighted materials. So I thought I would just do a couple of examples. I mean, one of the interesting things about copyright, I need to look at my nuclear countdown clock over here. Okay. So one of the other things about fair use is that it hasn't been legislated to death. There isn't a lot of descriptive text in the law about it. Instead, it's a body of litigation. So what you have is a lot of examples that went one way or went another way, et cetera, that help to begin to describe what fair use means. You know when you're watching CSI and there's this big blood spatter and you notice that there's like a rectangle missing from the blood spatter on the wall, right? And so the CSIs go, there must be a painting hanging on this wall because there's no blood spatter there, right? In some ways, fair use is defined the same way. Through the series of cases, you have this splatter of information that help to begin to define an outline of what fair use might be, but there isn't a description of the fair use itself. I hope that makes sense, and we can certainly talk about it more. So a lot of it comes down to examples and intent, et cetera, when you're trying to make decisions about how do you make use of copyrighted content. So, for example, here was an ad, right, of a guy in wingtip shoes standing on the ledge of a building, and you know, for purposes unknown, right? But you can draw your own inferences as to what those purposes might have been. And then there was another ad that looked like this. So the question then becomes, what is the copyrightable content in that first piece? Is the very fact that somebody is standing on a ledge looking down with the potential intention of ending their life copyrightable, right? Is that something that is enough of a specific implementation that it's copyrightable? And in this case, it turned out that it wasn't. So this particular image was able to win its suit that when they were sued from the other company that created that first image. So there are instances like that where the essence of a thing is universal enough that it's not copyrightable. But there was another example, for example, where there was a hip-hop artist, and they had a picture of him here with the, you know, bracelets and a watch, et cetera, particularly arranged, and it was later determined that the arrangement of the jewelry and how he was made out in the commercial was copyrightable, and therefore an ad that was done almost identically in terms of the wrists, et cetera, was an infringement. So you can see that these things aren't specifically defined with hard lines. This is a pretty famous case as well. There was a book written called The Wind Done Gone, which was a parody of the Gone with the Wind. And it was a retelling of that story, of that novel, but from the slave's perspective. And this was subject of a copyright lawsuit as well. And it was found by the court in this particular case that there was not substantial enough deviation from the original work for it to be considered a new work, right? Because it was literally the same story, the same characters, the same plots, the same dialogue, et cetera, just told from another perspective. So there's very little beyond the title and the conceit, if you will, of the book that was any different from the original one. So while it could be considered a parody, there wasn't original work put into to make it a parody, if that makes any sense. It was literally the same story, simply just retold, right? So in this particular case, the infringement suit was upheld. Here's another example. This is a familiar picture to many of you from your childhood, so it's very evocative. You know, might take you to a place you didn't know you'd go to in a session like this. But here's the Cat in the Hat, right? And then after the O.J. case, this book came out. The Cat Not in the Hat, right? And it was very funny, very interesting, and Dr. Seuss sued them, right? And so what was interesting about this is that the defense that was used by the publishers of this book was that because it was a parody, this infringement fell under fair use. But what the courts found is that because it was not, in fact, a parody of the original work, it didn't apply to fair use and, in fact, represented an infringement. So, again, it becomes important to kind of understand what it is you're trying to do. If you're trying to use the work for purposes of parodying and criticizing it, then it's a fair use. But if you're just sort of borrowing somebody else's copyright to parody something else, it's not. Many of you remember this image. This may be evocative in a way that you didn't expect in a session, although unless you go to Scott Stansfield's session, then I guess it could be different. But so this is a very famous Annie Leibovitz photo on the cover of Vanity Fair, right? Somewhat lesser known, but perhaps equally memorable, was this ad for Naked Gun 33 1/3. So, as you might imagine, Annie Leibovitz decided that she would, speak up about this. And it was a very interesting case because initially they said, well, it was a parody. Well, it turns out that from a legal perspective, its parody alone is not enough. It needs to also be a criticism. And so the lawyers for the publishers, for the studios that did this poster, started talking about how Leslie Nielsen's character was meant to embody someone who was unable to accept a woman that could do it all, and it really smells a lot like a justification after the fact, but they were able to, in fact, prevail in this case by representing this as a critique and parody of the original work. She went on to try and say that the way that it was lit, et cetera, the pose, were copyrightable material, but there was plenty of material dating back to Botticelli, frankly, that was able to demonstrate similar lighting and poses, because it turns out there was really only one way to cover yourself with your hands. And so these guys actually prevailed in their lawsuit, or in their defense against Annie Leibovitz under fair use claims. Here's another famous example, right? The Marlboro Man ad was reused wholesale. The picture was used directly, but with a new caption, right? And then it became very important what the purpose of the use was, that it wasn't for profit, that it was for criticism. And I think it helped, of course, that the model in the ad died of emphysema, right? The Marlboro Man. So despite the lawsuit in that case, this was upheld as a fair use of this image as well, all right? So some other things that come up, discussions that come up, public speeches or transcripts of government documents. Well, it turns out those things are, in fact, in the public domain. So if you go hear a speech and record it with your video camera, you can post it on YouTube. If you TiVo it off of NBC News, you can't, because that recording itself is copyrighted. It's not the fact that the speech was, but that that recording of it was. So if you take the recording yourself, you have the rights to put that up, but not if it's somebody else's. And the same is true of a transcript. I was out in the hall talking about public access to data, which is one of the biggest discussions going on in Washington right now, this idea of open government, right? The Obama administration is taking very seriously this notion of making it easier to get to things that you've had a hard time getting to via freedom of information, right? And so what form does that come out in? And if it's made available in the public, and then I do the work of kind of mixing it into something more usable, what are the rights that I now have as having created a derivative but yet more usable work, right? And those are issues being debated. But there's probably going to be a distinction between the form in which the government puts it out and the form that I might put it out, having accumulated from the government, indexed it, made it searchable, et cetera, right? If I do something separate with it. Another big one on websites is music playing in the background, right? And it's the same issue. You need to have the rights to the music. And it turns out in music in particular, there's two different types of rights. There's two rights holders. One is the songwriter, for which there's actually a compulsory license. In other words, it's very easy to get fairly cheaply the rights to, say, record your own version. To do a cover version of a song is pretty easy and fairly cheap, and it's subject to a compulsory license and not a negotiation. There's a fixed price, and you can just go do it. So that makes it very easy to, say, use a MIDI file or something like that as the background of your page. But if you're using an actual recording, that's got a separate set of rights associated with it that are often much more complex to unravel and much more expensive as well than the rights to the underlying words and music that were written by the songwriter. So again, not something that you can just do without permission unless you're dealing with stuff that's no longer copyrighted, right? And you can have a MIDI file of Mozart playing in the background and not have to talk to anyone. But a recording of the, Washington, of the National Symphony Orchestra doing Mozart is something that's got a copyright associated with it. And sampling we talked about a little bit. This is probably duplicative. It has to do with the size of the sample and making the minimum size of the sample necessary to do your criticism, your critique, your parody, et cetera, and to have a minimal impact on the market for the original content. So the other thing I just thought I'd throw in here is that if you are interested in trying to actually license the content for purposes of your website, these are some of the sources that you might go to get more information and to do that licensing. And very often it's easier than you might think because they're motivated to let you do it. And I do encourage you, as I said at the beginning, I put at the bottom here, these social networking sites, to look at their license agreements. Because it is true that copyright holders, when they upload things to Flickr or Facebook, are giving up some of their rights, which in turn allow them to grant some rights to you, but you need to be really careful about what they are. And this is the slide they added to remind you once again to do the 4-step evaluation form. Questions?
One question. can I copyright my idea? For example, if I want to build a new website, and then can I copyright that, or just the contents and image?
Yeah, I mean, there is quite a bit of evolving copyright law surrounding the look and feel and the effort that you put into a specific design of a website, and that can potentially be copyrightable. If you've created a really original layout, et cetera, that is something that can be copyrightable. When you talk about an idea, though, that's a different issue. Like, for example, if you come up with a new way of navigating through a web page, you may want to think about a patent instead of a copyright, because you only have to ask the people at Lotus who tried to sue Borland around that, and they failed, that copyright doesn't always give you the protection you want for a process-oriented protection.
All right, thank you.
Quick question. If you're, let's say you're using Microsoft Virtual Earth in an application.
Using what, I'm sorry?
Microsoft Virtual Earth, like the Microsoft
Virtual Earth
platform. Yes. Yeah. If you're using that in an application that you're building, and you want to reference it within your documentation or talk about it in some conceptual way, there's obviously a trademark symbol that has to go after the Virtual Earth name actually that goes in your doc. Can you list that at one spot at a high level and then just leave it out the rest of the doc, or do you have to include the trademark symbol in every iteration of that?
I don't actually know the answer to that. I believe that you need to continue to repeat the TM reference whenever you make use of the name.
Okay.
But if you send me an email, I'd be happy to find the answer to that question.
Okay, cool. That'd be great.
It's easy to find, actually. I just don't know it off the top of my head.
Okay, great.
And I'm getting the axe from the back of the room, but so I'm happy to just meet you out in the hallway, because there's another session in 5 minutes. But I'm happy to meet you out there and talk about anything you like. Thank you very much. I hope it was helpful.